Hello, good night to the guests, and good night to those who have joined the view and those who will come on the view. Tonight we have with us a very eminent panel, Dr. Francis Alexis, Dr. Francis Alexis KC, Ruggles Ferguson KC, and Cara Shillingford. But before we go into tonight's program, I just want to recognize those who are sponsoring this program. GM Professional Solutions, GMFM carried this program in Canada on FM radio, and also Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Good night once again. On 12 February 2025, the Eastern Caribbean Court of Appeal, in a majority judgment, overturned the decision of Justice Esco Henry, as she then was, in which she held, among other things, that two rules in the Statutory Rules and Orders number 28 of 2021, made by the Minister of Health of the Government of St. Vincent The Grenadines, were unconstitutional and unlawful. Rule 5 of SRO 28 required workers in a number of government departments, described as frontline workers, to take the COVID-19 vaccine. Rule 8.1 of the said SRO went on to say, in everyday language, that if you don't take the vaccine, you cannot enter the workplace. And Rule 8.2 followed up by stating, Rule 8.2 followed up by stating that if you do not take the vaccine for a period of 10 days, then automatically Regulation 31 of the Public Service Commission rule regulations apply. Regulation 31 states that if you are absent from your work for a continuous period of 10 days, unless the Public Service Commission determines otherwise, you are deemed to have resigned your position. The issue in the case, therefore, was not whether the vaccine was good or whether it was evil. Simply put, for the workers, their issue was whether, having decided not to take the vaccine, it should follow that they would lose their livelihood. For the judges and for the lawyers, the issue was simply whether regulations passed by the regulations put in place by the minister complied with the law, whether his indication, his mandate that the regulations, the PSC regulation would automatically would apply to those who do not take the vaccine after a period of 10 days, whether that was lawful. That was the issue, simply put, before the court. And it is this issue, we have this esteemed panel tonight. The panel, Ruggles Ferguson KC, as I said, Dr. Francis Alexis KC, and Cara Shillingford. Welcome to the panel. Welcome, Ruggles.
Yes, thank you. Thank you. And let me again, once again, commend you for identifying a very important topic, not just for St. Vincent, an important case that affects not only St. Vincent, but the entire OECS region, and beyond. It's an issue that has raised much debate, and of course, I'm quite happy to be on a panel with my fellow panelists, the esteemed Dr. Francis Alexis and my good friend Cara out of Dominica, who bravely led this particular case. And so, good night, and good night to your listeners and viewers.
Well, normally we say ladies first, but we'll have you first, Dr. Alexis, if you don't mind. You are muted, Dr.
I'm not
Alexis.
hearing him. Yeah, okay.
You're muted.
Good. I was saying thank you very much indeed, Ewart, for having me on your very distinguished Legal Eyes here with my good friend Ruggles, Ferguson, and meeting the first time electronically Cara Shillingford. I want to pay tribute to Cara because we are here due to her alertness, identifying constitutional issues of COVID legislation across in St. Vincent Grenadines, and she litigated the issues with very clinical skill, superb articulation, and admirable courage. So I do pay tribute to Cara Shillingford, the reason we are here. Thank you.
You're muted, Joseph.
I would say, let me just welcome my co-host, Simeon Collins. We had a little technical issue, but Cara, over to you now.
Okay. Good evening to my fellow panelists and also to all listeners and viewers of this program. This is my first time on Legal Eyes, and my friend Joseph has asked me before to join, but I really do not like public speaking, although I think it's very important. So I had said no before, but I think this matter is of such great significance, not only to the people of St. Vincent, not only to the litigants, but also to the wider Caribbean, the wider OECS, that I really could not refuse the opportunity. Thank you for the kind words, Dr. Alexis, coming from someone of your eminence and your high repute. It is a tremendous honor. It's good to see you again, Ruggles and Simeon, and I'm happy to be here. I believe that this kind of discussion is really important, not just for the courtroom, but it's important because the people who are affected need to be fully informed, or they need to be apprised of the different issues which are involved. The persons with disabilities, they have a motto which says nothing about us without us, which really simply means that when you are making decisions, or when orders or court cases are taking place about people, those people really should be fully aware of what is happening, and should have an opportunity to whether take action or do whatever it is that they can to make a difference. Of course, a person on the street might not be able to influence a court decision, but they can influence the actions of those in power, government officials or politicians, etc. So it's really important that we have these kinds of discussions so that people are kept up to date on current affairs, and they get an opportunity to weigh in on the issues.
Yes, thank you. Well, there's no doubt in the gravity of the context in which this case arose. COVID-19 was something completely new. Never in our lifetime have any of us seen anything as that pandemic. And of course, those in political office have the responsibility to respond, to react, to take measures so as to protect lives first and foremost. But in doing so, and I think
Yeah,
that
same as if we
we have a technical issue.
I'm hearing you loud and clear.
Yes.
I do.
Yes. In doing so, and that's the point of view of the claimants in the case, the respondents, and in the Court of Appeal, that one had to strike a balance. There were certain rights and so which should not be interfered with. I think they will say unless it was absolutely necessary to do so. So having said that, I want to now seek to leverage, seek to get the benefit of the evidence of Dr. Alexis to first of all comment and give his own take in terms of the situation that would have been faced and the measures that were taken, the constitutionality of the measures or lack thereof, the judgment of the court, all of those factors, if you may know.
The situation that was faced in St. Vincent Grenadines at the time, 2021, was undoubtedly, as you indicated, dire. We were all in the Caribbean globally in the throes of a very vicious pandemic, COVID, and there can be no doubt that governments had to respond. But we have constitutions in the Caribbean which regulate how the state may respond, whether to a public emergency or to safeguard the interests of public health, public order, etc. And what Cara and her team were pointing out to the court was that in their view, the view of the Cara Shillingford team, the government of St. Vincent Grenadines may have clashed too much with the Bill of Rights. A number of issues arose. First of all, issue number one: was the Parliament of St. Vincent and the Grenadines empowered to give to the Minister of Health and the Minister of National Security the powers given to them in the Public Health Amendment Act 2020? That question arises because the ministers proceeded to, in regulation, special regulation 8.1 and 2, lay down grounds for removal of public employees from their public office. Maybe I better go to what Cara was saying to the court.
Doc, if you wish, we can put the judgment up on the screen. So if by any chance you just want to point us to a paragraph, we can do so.
Yes, sir, I would want to go right away to the judgment of the learned trial judge. Madam Justice Esco Henry.
Okay, unfortunately, we only had
Starting at paragraph 118
okay. Well, just read out.
of the learned trial judge's judgment. Now, this is what Cara Shillingford was saying to the court. That the stipulation under Regulation 8.1, that a person who fails to take a COVID vaccine is to be treated as absent without leave, touches and concerns the terms and conditions of their employment. And this is it now. This is she's getting here now to the nub of public law. Because the nub of public law is that, in this respect, when Parliament gives up power to a public entity, that entity may exercise only the power that was expressly given or what was reasonably incidental thereto. And this really is the crux of the litigation. And Cara is here telling the court that the making of such regulations, 812, which I've just condensed for you, is not expressly provided for under the parent provision, which was section 43B of the Public Health Act as amended in 2020, and is not incidental to the purpose for mitigating or remedying a health emergency, and therefore the minister exceeded his legislative power by making those regulations. This is the crux of the ultra vires doctrine. The Parliament gives you a power, you can exercise the power expressly given, or what is reasonably incidental thereto. The learned trial judge is responding to that when she said that, referring to section 43B(2) of the Public Health Act in Vincent The Grenadines as amended in 2020, is giving a whole range of powers to the Minister of Health, one of which expressly is to stipulate vaccination against COVID by consent, consensually. But there's nothing in that section 43B(2) which says in terms that the minister may make regulations providing for compulsory vaccination. So the learned trial judge is saying here, while the subsection lists 8 specific types of measures, among those there is none which covers deeming a non-compliant employee to have resigned his office and his office to have ceased, and no clause exists, commenced the learned trial judge, under which they may be appropriately subsumed without recommendation by the chief medical officer. This is the core of the issue before the court. Did Parliament expressly or by reasonably incidentally thereto empower the Minister of Health to regulate compulsory vaccination? Now, let me quickly say this. The learned trial judge is addressing this issue frontally. I don't see where the Court of Appeal does so. I'll explain why later on. They have their reasons. Later on, I'll come to them. But for the time being, the learned trial judge is saying that power to require compulsory vaccination against COVID is not expressly given. it is not reasonably incidental to any of the powers expressly given, and therefore in public law, classic public law, the ministers had no such power under the Act. This is an issue which presents problems to judges all over the world. One judge might say, I consider that the power was reasonably incidental. Another judge in the same court, you go to the Privy Council, there was a case coming out of Bermuda, and the issue was this. Statute is enabling the Hamilton Municipal Corporation to lease out its lands. Express power. No express power given to the council to give a lessee of the lands support to raise funds, to go to a bank, for example, and guarantee a loan. Now, was that power implicitly given? And even the Privy Council was dividing very fiercely over it. So I'm not suggesting here, Ewart, that there is only one and one only answer to that question. But it would have been nice to see the Court of Appeal address it up front or at all, and they haven't done so. So I pause here.
Ruggles?
Okay, thank you. The starting point, and this is what makes this case such an interesting constitutional cases are important because they affect not only the parties that go to the court to get society, and when we look at constitutional matters, it's always about the balance between the right of the individual and the greater interests of the community. And as Doc indicated, it's never really an important question to answer and to address the right way. And I just want to make the observations early in this case that the High Court judgment was delivered by Justice Esco Henry, well-respected, not just High Court judge then, but she's also a Justice of Appeal. She sits on the appellate court now. And in this case also, you had a majority judgment in which there was a powerful dissenting judgment, in which the dissenting judgment given by Worldbank J.A. Concluded that the respondents, as he said, were grievously wrong by unconstitutional and unlawful acts. These are very strong words, grievously wronged. And in his view, as he indicated, the measures taken were draconian. He also used the term draconian. Now, this case touches several different issues. Section 6 of the Constitution, and I wouldn't go back to repeat what Doc indicated, but two rights under the Constitution. One, the right not to be deprived of property, and two, the right not to be deprived of your pension. I think the particular sections engaged was section 6, which is the identical section for deprivation of property in Grenada, and section 88, which is the equivalent of our section 92, but almost in identical terms, which protects pension rights. It also touches and concerns the role of the Public Service Commission, the constitutional role of the Public Service Commission in hiring, discipline, and firing public workers, and of course in making regulations to regulate its own procedure. And as most of these Commonwealth constitutions state, that the Public Service Commission in making decisions is independent and is to be directed by no other entity or authority. And also, touching on the point that Doc made, it addresses this very important separation of powers principle, the role of the executive, the judiciary, and the legislature, with the legislature responsible for making laws. And I think here the issue in the context of the separation of powers is whether or not the parliament as the executive arm, as the legislative arm of the state, gave up its rights and constitutional responsibility to make laws to the Minister of Health in this particular instance. And there's a well-known principle that you may delegate authority to a minister or other subordinate body, but you must retain effective control when doing so. And of course, it has it addresses the important role of the judiciary that the judiciary plays in interpreting laws. So there are several important constitutional components that have been embraced by this particular case. As I understand it, what the majority in the Court of Appeal is that one, you have the section, there is a section 43, and there is a section, I believe is 147, that under the Public Health Act, that the minister had the power to make certain rules and introduce certain protocols under section 147 of the Public Health Act in the context of an emergency, being the COVID-19 emergency. Now, the question which I felt was dealt with a bit mechanically, if I may say so, by the Court of Appeal in really interpreting constitutional provisions. And we have the famous case, I believe, is Fisher, that and it's also a Bermuda case. But when you are interpreting constitutions, that you must give generous interpretations that will give the full plenitude of rights to the affected persons before the court. And since there seem to be the learned judges of the majority and all very distinguished and well-respected judges, and I must say here that any criticism at all leveled is not of their own abilities, but as Doc says, you may have the identical facts before you, and brilliant minds come to the same conclusion. And I think that is one such example here. But as I understand the case, and Cara is here, but what really, in essence, one side is saying, listen, there's an emergency. The vaccine mandate has been introduced. You must get vaccinated if you are to continue, effectively continue your employment in the public service. Because if you don't get vaccinated, you can't enter the workplace. And if you don't enter the workplace, you will be deemed to have abandoned your job. And if you abandon your job, as Regulation 31 of the PSC regulation state, for 10 consecutive days, if you don't show up, then you are deemed to have abandoned your job, and effectively you are terminated. Now, that is, in essence, what the effect of those provisions were. Stripping apart all the technicalities and the fact, that is what it said. So you don't take your vaccination, you can't enter the workplace, you're missing in action from the workplace for 10 days or more, you're deemed to have abandoned your job. Now, abandoning your job brings with it certain consequences. And I seem to be understanding the court to be saying that those who were not put front and center before the court pleaded in terms of the effect on these respondents of not showing up in relation to their pension rights. Because it is well established by authority that pensions, and whatever money entitlement, money you may be entitled to, that forms part of your property within the meaning of Section 6 of the Constitution, that one is not to be deprived of property. So if you are deprived of your pension, you're deprived of your property. And what I understand, the respondents to be saying, yes, there is a vaccine mandate. We did not take the vaccine for whatever religious, medical, or conscience issues there. We did not abandon the work, because whether you abandon your work is a question of fact. You don't show up. But they are saying, we were available to show up. In fact, we presented ourselves. And until we got that the letter of termination, it's not a voluntary, we didn't voluntarily say that we are not showing up at the workplace, and which is what the dissenting judgment heavily focused on, the judgment of Wallbank, because abandonment, as he cited, is a voluntary relinquishment of your position. In other words, you have a job and you just, on your own steam, fail to show up to that job. And what was being said here is that, listen, we were ready to show up. We were ready to perform our duties. And but they said we could not enter the workplace. So how could we have abandoned our job when you say, well, we stand ready to perform our duties, but you say we can't come? So I think in essence, what Wallbank and the dissenting judgment said is that, listen, and that's where the principle of natural justice came in. And the Court of Appeal majority took the view that, listen, if you didn't turn up, then you're deemed to have abandoned your job. And World Bank J is saying, listen, if this is so automatic and there was no opportunity before terminating them to say why, whether it was for X reason or Y reason, that they did not show up, then in those cases, they were denied, well, natural justice, the process of natural justice, but more importantly, in this case, that the effect of you abandoning your job, and I'm wondering, I don't know what the arguments were before the Court of Appeal, but it is if you abandon your job or you are dismissed from your job, then automatically your pension rights are affected, because pension rights not necessarily just automatic based on years of service. So what I'm understanding the respondents to be saying, and I was not privy to all the arguments, but listen, if you tell these people that they have abandoned their jobs and placed them in a particular category of abandonment, then their pension rights would automatically be affected. And it's interesting how World Bank J dealt with that. But probably I should come in. I think I'll come in after as the discussion evolves.
I just want to add though, Doc, I think part of the context is that initially the law said that any mandate, any vaccine program should be voluntary. So part of the context is that I think the Parliament amended that, and they just removed the word voluntary. But I think you're saying that it is still a matter of construction whether they had that power to do something that was compulsory. Without that,
it was in the amendment of 2020,
yeah,
where the Parliament is empowering the Minister of Health to make regulations to mitigate or remedy a public health emergency. And subsection 2 starts this way: where the minister has declared a public health emergency, the minister, on the advice of the CMO, may implement special measures to mitigate the emergency, including provisions regarding voluntary vaccination.
yes.
Now, precisely because the section talks about voluntary vaccination and does not talk about compulsory vaccination, there arises a proper issue. Was then compulsory vaccination authorized by the Parent Act?
Yeah, but what I was saying, there was a subsequent amendment when the word voluntary was removed.
But not in the case before the High Court. Definitely not. When I speak subject director, Cara is here. She could help us with that.
Yes, Cara, unmute yourself.
Yes. Okay. Thank you. Yeah. So there was an amendment. However, the amendment simply removed the word voluntary and left it as vaccination. The amendment did not say involuntary or compulsory. It simply left it as vaccination. And what we argued is that simply saying that there could be a vaccination program, whatever was the word in use, that does not communicate that you can force persons to take the vaccine. If it is that you're going to go as far as forcing people to take a drug, into their body, which, I mean, that is a gigantic thing to do, to force an individual to, take something that he does not want to. It goes against your right, your human dignity, your right to protect your person, your life, your health, everything. then the words have to be clear. So at no point was any act passed which says that there can be a compulsory vaccination program or, mandatory.
Yes, but when the matter was at the High Court, when the judgment was given, was that amendment already made? That is the issue now.
Right. So at the time that it was argued before the High Court, the amendment had been made, and the Act simply referred to the Act did not state voluntary and it did not say involuntary. So it was silent. It was silent
It
on
was
that.
silent.
It was silent.
Now, the Court of Appeal rested on Section 39 of the Interpretation Act and Section 147 of the PHA. Let's read those sections. Rested on those provisions to say that the minister had the authority to make the compulsory vaccination provisions. These are the provisions. Section 39 of the Interpretation Act, where any written law confers power upon any person to do or enforce the doing of any act or thing, all such power shall be deemed to be also conferred as unnecessary to enable the person to do or to enforce the doing of that act or thing. With the greatest respect, this cannot empower a minister to make regulations saying that vaccination, whether against COVID or anything else, is compulsory. This section 39 assumes that the written law it is talking about is valid. So if the written law is being questioned, you can't turn around and say the written law authorizes it to be done. You have to go back to the question, is that written law valid? Therefore, in my respectful, humble submission, I cannot see how Section 39 of the Interpretation Act by itself can enable the Minister of Health to make vaccination compulsory. I know all judges of the Court of Appeal saw Section 39, including the dissenting judge. He too agreed that Section 39 enabled it to be done.
Yeah, he did.
He too agreed that Section 147 of the PHA enabled to be done. So let's have a look at Section 147.
I don't think he agreed with that part, though. The dissenting judge should agree with that.
No, the dissenting judge agreed that Section 39 enabled...
39, yes, but not 147. Because what he said if 147 gave them that power, there'd have been no need for the amendment in 43. But he agreed with 39.
He agreed with 39.
Yes, he did.
No issue about that at all.
Yeah.
Now, on my reading of what he said about 147, he considered that 147 was wide enough. That's my reading of it.
Okay, I understand.
Whether he did or not, certainly the majority judges in the Court of Appeal
Yes,
did.
they did. They all agree. Yes.
So let's look at 147. The minister shall have power to make rules generally for the carrying out of the provisions of this act. That provision cannot enable the minister to make regulations setting out terms and conditions for the removal of public officers from office when, under the auspices of the Constitution properly, PSC has already in its regulations set out terms and conditions for removal from office, which takes me back to another part. No. Did Parliament itself have the power to do that? Namely, to set out terms and conditions for the removal of public employees from their office? Remember, these issues in public law don't come with a one and cut answer. Remember that.
Mhm.
They are always, almost always amenable to different interpretations. However, Justice of Appeal Dr. Eddie Ventos was quoting the Privy Council in a Trinidadian case, Thomas and the Attorney General, as authority that Parliament may make these provisions setting out terms and conditions on which public employees may be removed from office. But if you look at the excerpt the learned Justice of Appeal had in front of him, it doesn't say anything about terms and conditions in relation to removal from office. Well, you may say, well, that is implied. Maybe it is. But if it is, then it has to be explained. But on its face, it doesn't say anything about terms and conditions for removal from office. It is true, Ewart. Now, the Privy Council in an Antiguan case, De Freitas and the Permanent Secretary in 1999, and the Court of Appeal of the Eastern Caribbean States proceeded on the assumption, as it were, that the Parliament can make these provisions, because in that case, in Antigua, Parliament passed a law saying, in effect, the public officer, civil servant, who gets into a controversy, political controversy, would be skittled out, and De Freitas was. But there was no addressing of that point. It was taken for granted. So we don't have yet a case which specifically addresses the issue. By contrast, in a Grenadian case, Donovan and the Attorney General, this is the retrenchment case in Grenada back in 1992 or thereabouts. And Parliament in Grenada amended the PSC regulations to say that a person who is retrenched under the Act cannot avail himself or herself of regulation, I think it was 46, of the PSC regulations. That was the part of the regulations entitling a retrenchee to make representations to the PSC on the basis of which PSC might order that the public employee be no longer retrenched, but, for example, may be transferred. And the Court of Appeal, a very strong Court of Appeal, Dennis Byron is delivering the judgment on behalf of the court. At the time, Byron was Justice of Appeal. Included in the court was Sir Vincent Flossack, CJ. And they said, they decided, and they dedicated a whole page to the issue, saying that Parliament has no power by an ordinary act to change the PSC regulations regarding removal of public officers from office. So what then is the point, Ewart? The point is this simple. We need the final court in our system, which is the Privy Council, to specifically address De Freitas, Donovan, and lay down as clearly as can be whether Parliament can stipulate terms and conditions for the removal of public officers. I'm getting a little feedback.
We get some feedback. Bentley? Doc, have you put on another device?
No.
Bentley?
Device I have on.
Okay, just
So let me
continue.
continue. And more importantly, whether Parliament can authorize ministers of government to lay down terms and conditions for the removal of public employees from office. Let me tell you why I am zeroing in.
Just hold on a minute now.
It's getting a little hot in here, it would appear.
Yes. Okay, see if you go on. Just go on. Yes.
Good. The reason why we need the final appellate court in our system to lead on clear guidelines is this. If you look at the Vincentian Constitution, section 77, subsection 2, it is specifically saying a person shall not be qualified to be appointed as a member of the commission if, among other things, rifling in A and B, essentially, he or she has been or is a member of parliament, or even a member of a political organization in St. Vincent. In that same section, the Constitution is specifying that the Commission shall not be subject to the direction or control of any person or authority. The Commission may, by regulation or otherwise, regulate its own procedure. What are these provisions indicating? Clearly, that they don't want parliamentarians laying down terms and conditions of work, certainly removal from office regarding public employees. Therefore, we do need our final court specifically addressing Thomas, De Freitas, Donovan, and letting us know whether we can have ministers of government saying on what terms and conditions may public employees be removed from office.
Yeah. Cara?
Okay. Firstly, I endorse everything that has been said before, by my co-panelists, and I just want to add a few things. I think it's important for us to look at the law generally and consider the history of law and the purpose of law. The main purpose of law is to obtain justice, to create a just situation. Over a period of decades or centuries, laws have developed in such a manner as to protect persons. Now, we have a body of employment law that has been developed over the years to protect people from wrongful dismissal, unfair dismissal. What this means is that the employer-employee relationship isn't one where the employer would have absolute control. The employer can abuse an employee and, simply throw the employee out of the workplace at any given time. In basic employment law, where private persons are involved, if you are going to terminate a person's employment, you have to follow a particular procedure. You need to have cause, and you need to follow the procedure stated within written laws in most of our OECS jurisdictions. Now, if in a private employment situation, you want to terminate without cause, you have to give the person appropriate notice, or you give them compensation in lieu of notice. You give them, money so that the person isn't just thrown out in the cold. What we had in St. Vincent and the Grenadines is that the government that was supposed to represent the people, to protect the people, took a decision to simply throw individuals out of the workplace because of their refusal to take a vaccine into their own bodies. Right? These individuals were thrown out without any payment package, without any, termination plan, nothing. These are people who had mortgages. persons who had medication to purchase, they had children to feed, they had rent to pay, etc. That in my mind and in the mind of any reasonable human being, that is inhumane. It's unacceptable. It was absolutely wrong, from a moral as well as a legal perspective. Now, what I found interesting, that is not in any of the judgments, and it certainly was not argued by either side. But what I found interesting in this case was that these ministers, they created a list. They selected a list of public servants and police officers who they decided to dictate should be the guinea pigs. You must take the mandate, and if you don't take it, we're gonna fire you. But they did not put their own names on that list. On the list of persons who were mandated to take the vaccine, you don't see cabinet ministers. You don't see that. So what gives you the right? What gives you the moral authority to force someone to take a drug into their body, especially at the time when these vaccines were given, like emergency authorizations? These are not things which were tested and which had been around for a very long time. Additionally, the evidence of the chief medical officer in this case shows that the government itself had evidence to show that at least one person had died from taking the vaccine. That was in her affidavit. So you're forcing people to put their lives at risk. I think it is absolutely wrong. But in addition, so stepping away from those arguments, I think as Ruggles and Francis quite aptly and efficiently highlighted, the Constitution exists so as to protect people from government abuses. I think Justice Walbank, in his dissenting judgment, he started with that. The Constitution exists so as to create a balance so that the government does not abuse its power by infringing constitutional rights of people. And it cannot be. It is not the case that simply because there is some public emergency, something happens, that the government has a free pass to do whatever it wants with persons. If it is that we're giving them that free pass to say to public officers, either take the vaccine or go home, then the next pandemic which comes around, what is it that they're going to do? Are they going to authorize police officers to go onto the streets and simply start injecting people with drugs, with vaccines? So it's a slippery slope. And I think that the purpose of the court, the judiciary, is to take a stance. Obviously, this is a controversial case, and members of the judiciary, for whatever reason, they might be hesitant about ruling against a government regime. However, I think in a case like this, when I read the judgment of Justice Henry, which was extremely well reasoned, and the dissenting judgment of Justice of Appeal Walbank, I think that this was the perfect case for the court to take a unified stance and say to the government, hey, what you did was wrong. We will not allow it to stand. Now, on the issue of the Public Service Commission, the Constitution has an entire section that deals with the Public Service Commission. As we saw in the case of Endell Thomas, the Privy Council stated, and it is the law, and that has been recognized by several courts, these commissions, Public Service Commission, Police Service Commission, were created to insulate public officers from the influence of the government of the day. The idea is that the current regime should not have that kind of absolute power, absolute control over public servants. Public servants should be able to do their jobs independently. And if you have a situation like what the Court of Appeal would presumably allow if if that decision stands, where a government can simply dictate to the Public Service Commission when they must deem a person to have resigned a job, that makes nonsense out of the Constitution. It robs the Constitution of all meaning. So I think this is a it's an important case. It concerns human rights because, as I said, it touches human dignity. You cannot force a person to take a drug into his body against his will. It touches employment law that has been developed for centuries. So you cannot simply throw people out of the workplace. There are rules that govern employment law, and it concerns constitutional law, and a lot of the other areas which my learned friends have already addressed. So in some, what the government did was extremely draconian. It was disproportionate. And I think the fact that it was draconian was highlighted by the fact that just before, Joseph, if you remember, just before this matter came up in the trial court, the government issued a press statement saying, all persons who have been terminated, you can reapply. Whether you are vaccinated or unvaccinated, we want you to come back. Just reapply. That is ridiculous. So at this point, you are okay with unvaccinated people being back into the workplace, but you're telling them reapply, and I will choose who I like, who I dislike, who I allow to come back in. So this situation in St. Vincent and the Grenadines, it is just absolutely wrong. I mean, this is a complete. It's horrible, as it relates to the body of laws which have developed in a progressive manner over the years. It is actually, in my mind, it's regressive. It goes back into a direction that we don't want to go back to. So it's like a backsliding, a human rights backsliding, essentially. And I'm looking forward to the Privy Council having an opportunity to change this decision and to set a proper precedent, because this may not be our last pandemic. Today, it was these police officers and public servants. Tomorrow, who might it be? What might the vaccine mandate be? And, of course, there was also the discussion in the dissenting judgment about the fact that the government did not declare a state of emergency. They did not go down that venue, but they chose to go down a very strange path where in the COVID-19 Miscellaneous Amendment Act, Parliament essentially authorized any minister to amend any of the laws listed in the schedule, which to me, it is complete nonsense. That's not how laws, that's not how Parliament is supposed to operate. So I feel obviously very strongly and passionately about this case.
Very passionate about it, is correct. Okay. I just want to ask Doc, as I understand the Court of Appeal judgment and also the arguments of the appellants in the matter, the Attorney General, the Minister of Health, and so on, they are saying, listen, Regulation 8.1 does nothing at all in addition to what would have happened by simply applying the Public Service Commission Regulation 31. I think in their words, they said that these words were mere surplusage, surplus words, the words which said that if you don't take the vaccine, you will be deemed to have been absent from your work. You cannot go to work, and you will be deemed to be absent. And then they are also saying that with regard to Regulation 8.2, which says that the Public Service Commission rules apply, it is doing nothing more than just alerting the persons who are being required to take the vaccine that, listen, if you don't take it, this is what will happen, because there is this regulation from the Public Service Commission that you are obligated to follow that regulates you. And if you don't take the vaccine, all that will happen is that this regulation will kick in. In other words, basically they were saying, listen, we have not directed the Public Service Commission. We have not done anything. Basically, it is not us. It is the Public Service Commission regulation, which has been there for decades. I don't know if you just want to comment on that.
But that cannot be true, because Regulation 31 kick in only if a disciplinary offense is committed. And there was no disciplinary offense called refusing to take a COVID vaccine until Regulation 8 was made. So without Regulation 8, there was nothing regarding which the abandonment provisions in Regulation 31 could hang on to. As a matter of fact, it took Senior Counsel Anthony Astafan a good while to latch on to that point which Justice of Appeal Ventos was generating. He didn't see it. And it took some time for Justice of Appeal Ventos to lead him up that path. But it is quite clear. For Regulation 31 to kick in, there has to be an offense committed. And before Regulation 8, there was no such offense. Furthermore, Justice of Appeal Dr. Eddie Ventos is saying that in effect, Regulation 8.1 serves up what he calls, in effect, automatic disqualification. So let's have a look at what 8.1 says to see if there is such thing as.
Bentley, can you bring up the judgment?
No, let's go to both 8.1 and 31. Take them together. 8.1. An employee who without reasonable excuse fails to comply with Rule 4 and 5 must not enter the workplace and is to be treated as being absent from duty without leave. There cannot be any automaticity here, because whether an employee had reasonable excuse or not is a matter of fact. And Justice of Appeal Wallbank has that in his hand. He is explaining that the Commission can't determine whether a person was without reasonable excuse without first hearing, or at least providing an opportunity for a hearing of a particular officer. Similarly, under abandonment of office, an officer who is absent from duty without leave, etc. You cannot determine whether the officer was absent from duty without leave, without first hearing him. And Wallbank is emphasizing that point. He says, whether or not, he's saying in his words, the PSC jumped to the conclusion that the respondents had no reasonable excuse for non-vaccination. But Wallbank is explaining, well, you can't come to that conclusion unless you give them an opportunity to be heard. So this idea of automaticity, the regulation in Grenada on abandonment is slightly different from that in St. Vincent. And in the old days, they used to be talking about automaticity. But we have been able to show them there's nothing automatic about it. And it's a simple matter. I can show you, for example, let me read this letter from the PSC, blotting out dates and people's names. This is how it now reads. Dear so-and-so, PSC noted that you had not reported for duty from blank date to blank date. Neither did you communicate it with officials in your ministry. And PSC goes on to say, PSC has directed that you be requested to report for duty on such and such a date, failing which you will be declared as having abandoned your office. So the PSC is providing an opportunity to the officer, report for duty, or explain yourself. There's no automaticity about that. So I think that the concept of the automatic exclusion, and even on grammar, if you look at the provision, even on grammar, 31, abandonment of office. An officer who is absent from duty without leave for a continuous period of 10 working days, unless declared otherwise by the commission. And the unless comes first. Unless declared otherwise by the commission, shall be deemed to have resigned his office. So two things here. There is no humbug to proper public administration to send them the kind of letter I was just reading to you from the Grenada PSC. And also it is saying on its face, unless declared. So you go to the abandonment, the deeming, only if the PSC did not declare otherwise. Now I want to get on to, before time runs out on me, I want to talk about proportionality.
Yes.
Cara spoke about that. Justice of Appeal Wallbank is saying that there was no need for any draconian measure of removing the officers from office. He says that there were at least two other options that mentioned in the regulation. You could have stopped them from coming to the workplace, and you could have disciplined them. He also goes on to say you could have put them on leave without pay. Let's spend a little time on that. If you had put them on leave without pay, wouldn't the same issues arise? Namely, that you are enforcing a measure which is too draconian because you're taking away their pay. And the alternative would have been stop them coming from the workplace or discipline them. In other words, I am not able to agree with Cara and Mr. Justice Wallbank that these measures were disproportionate. Whether they were necessary or not is not the point. It is for the respondents to show that there was, so to speak, a less severe measure which could have worked. And Anthony Astafan is saying it is skywriting to tell the officers don't come back into the office and even discipline them. I am not impressed with Justice of Appeal Wallbank saying you could have taken away the pay, send them on leave without pay. Because he himself, on his own reasoning, would have had to come back and say there were less severe measures. And he perforce had to go to leave without pay because he recognized that simply excluding them from the office physically or disciplining them wasn't going to work. So I'm sorry, Cara, I am not seeing a case made out for disproportionateness in this case here. If I am wrong in all the other points I've made, I'm agreeing with the majority in the Court of Appeal that there is nothing disproportionate about what happened here. I'm sorry.
That includes the stipulation that they would be deemed to have resigned? I know you disagree with that part.
I am saying that the stipulation deeming them to have resigned, to me, needs further debate. I don't think the Court of Appeal did justice to that. So that is why I'm saying we need to go to the final court and see what would be laid down there. I am confident in what I've said before disproportionateness. But if I'm wrong on those points, I agree with the trial judge that the principal legislation did not give the ministers that power. I'm agreeing with the learned trial judge on that. But when we get down to disproportionateness, I am not seeing how Justice of Appeal Wallbank is disposing of this convincingly, especially when he brings in the part about you could have put them on leave without pay. Because if you did that, the argument still is alive. Why take all the pay?
Yeah, but I guess what he's saying, it is less severe, less intrusive, less draconian to say, okay, you lose 3 months' pay. That to say, I lose your job forever.
Suppose actually, COVID started in 2020. It reached St. Vincent about February 2021 or thereabouts. Maybe. How do we know how long it would have lasted?
Okay, I think, for example, Doc, you have the case in Grenada with SGU workers, as I understand it. They said, listen, you can't come in the workplace, but they have never told them that they are terminated.
Yes.
So wouldn't you say that is less severe, less intrusive than saying you can't come in the workplace and you lose your work forever?
Of course it is less intrusive. But all I'm saying is the argument still would have survived if you took all the pay. You can't come in the workplace. Yes.
Yeah.
You agree with that, don't you?
I agree the argument will still be there to say you shouldn't take their pay. Yes. When you compare the two, I think that was the point Justice Wallbank was making. When you compare the two, taking away somebody's entitlement, the salary, they work forever, permanently, in a context when everyone knew that this was temporary. Nobody expected COVID to last forever.
How temporary? It would be temporary.
Huh?
If it had gone on for a year, 18 months.
Yes.
What about the people's pay?
No, I take the point of that it is still severe.
Of course.
I agree with that fully. I don't know if Ruggles or Simeon, you have a question or anything? I want to go to the chat just now because there are a number of people take comments and so.
Okay. Sorry, go ahead.
Ruggles?
Yeah, sorry. Yes. Well, the issue of the proportionality test, again, is an important issue that arises in the case. And because I was not involved intimately with the case and really depending on the judgment to make my comments, I think it's important to understand the context of the proportionality test here. Because when you're dealing with constitutional rights, it's all about these 3 words, striking a balance. Striking a balance between the rights of the individual and the interests of the wider community. And one, again, has to readily concede that it was not an easy issue, COVID, for any government anywhere in the world to deal with, including the government of St. Vincent and the Grenadines. I'm not too sure I agree with Doc on the approach to the proportionality test. I agree with him to the extent where he says, listen, the taking away of the pay will result in a cause of action, a constitutional cause of action. Maybe it will be for less damages, for example, because the consequence will be less. However, if you look at the proportionality test, there are 4 limbs to the proportionality test. The first one is whether it's objective, whatever was done in this case is sufficiently important to justify the limitation of the fundamental rights. And we know that fundamental rights are not absolute. And the Constitution itself circumscribes where a parliament can pass legislation which effectively can take away those rights and where it will be justifiable. And public health measures would be one such area. Public order, public health, public safety will be applicable. And in this case, it's public health. So let's say whether the objective is sufficiently important to justify the limitation of a fundamental right. And let's say the answer is yes, because in the conditions of emergency are different from the normal course of things, and where the community interest is affected, people are dying, people are being hospitalized, the virus is spreading like wildfire, then you must expect a government to rise to the occasion to introduce measures to deal with it. So let's say that the first question, the answer to the first question is yes. The objective is sufficiently important to justify the limitation of a fundamental right. The objective here to save lives and prevent the spread of the virus. 2, whether it is rationally connected to the objective. So what was done was rationally connected to the objective. So let us say, for argument's sake, that the answer to these 2 questions are in the affirmative. Then you have the other 2 questions. Whether a less intrusive measure could have been used. And Doc has referred to the automatic nature of it. And that's where therein lies the problem. So it is for the state. Effectively, what is said here, and I noted that the Court of Appeal indicated that this is not about this case is not about the constitutionality of the mandatory vaccine, whether or not it was constitutional or not. However, situation where I think is Rule 5 says that if you want to continue working with the government, you must take the vaccine. Point 1. 2, and that's barring. Let us say outside of the very important points that Doc made of the role of the Public Service Commission, I think, which is not sufficiently recognized, their independence, because it is the Constitution that says that the PSC is authorized to make rules to regulate its own procedure. That's given by the Constitution itself as the supreme law. So, but let us say, for argument,
We lose Ruggles up in this. You want to comment on anything there this time?
Yes. Okay. So, Joseph, you know that this was an argument which I found to be most difficult when we were preparing for this case. It wasn't an easy argument for me to make. But I see Ruggles is back, so maybe I'll let him conclude, and then I'll speak on this.
Yes. No. The third limb is whether a less intrusive measure could have been used. So you have here an edict which basically says if you don't take the vaccine, you can't come to work. And if you don't come to work and you stay out of work for a continuous period of 10 days, regulation 31, then you have deemed to have abandoned your work. Now, the question is whether or not in those circumstances where apart from the issue of opportunity to be heard, which the majority of the Court of Appeal dismissed here, is that, listen, this is simply, as they described it, you are deemed to have abandoned your work if you did not do these steps as dictated to by 81, a reading of 81, 82 and regulation 31. So it's almost like those statutory offenses, strict liability offense. Is either you do it or you don't do it. And if you don't do it, those are the consequences that the law says must be visited. But, for example, less intrusive measures, could it have been in the time of COVID that people could have worked from home, for example? That there is some flexibility introduced, and I'm not too sure how the respondents dealt with that at the High Court. But instead of saying if you don't come to work, you lose your work, to look at ways and means of actually allowing these individuals to work from home via Zoom or whatever, make provisions that would allow them to do so. And the fourth aspect of it, which is the striking of balance component, is whether having regard to these matters, that's 1, 2, 3, and to the severity of the consequences, a fair balance has been struck between the rights of the individual and the interests of the community. This proportionality test is a test that is applied in most constitutional matters where you are attacking the legislation or the rules or regulations made. And so I think the key issue here is whether or not, given the severity of the consequences, and I found it interesting that in the World Bank dissenting judgment, he actually said that the respondents presented evidence that they would lose their pension, and that was not rebutted, as he put it, by the appellants. So he did say that, whereas the majority is saying that there was no evidence, and certainly no sufficient evidence to establish that these people would have been affected, that the pension rights would have been affected. And the majority also said, which I found a bit curious, that that they can still apply. They can still apply after they are terminated if they qualify for the benefits. It's a question of qualification and entitlement. Because even if they were terminated, they notwithstanding that, they may still qualify and be entitled to, and therefore, subsequent to all of this, they can still apply for it. So in essence, they have lost nothing. But I think it's a well-established fact in terms of the operations of the public service. And even the private service, if you resign from your job, or you deem to have abandoned your job, then that will automatically affect what your benefits are, including your pension benefits. So I found it curious, and as Doc has indicated, and he has put it in very stark terms, that Regulation 31 really, it's a disciplinary issue. And it's a fine example of what he quoted there. That listen, You ain't come to work, you didn't show up, there might be a good reason why you have not shown up. And therefore, you ask a question. You don't treat it like a strict liability offense. There's a no parking sign here. And if it says no parking and you park, then that's an offense, you charge. Or you have to drive with a driver's license. If you don't have one, that's a strict liability offense. So it's almost equated that, listen, you have not shown up for 10 consecutive days. Once you don't show up, you deem to have abandoned your job and whatever benefits, because the way you have dislocated yourself from the public service, or the way you are terminated from the public service, impacts directly what benefits you are entitled to. And I dare say, impacts whether you are qualified, or whether you qualify to receive a pension or not, or whether you are entitled to receive a pension or not. So, yeah, I just wanted to...
Yeah, before we come, Cara, I just want to say that I put that in terms of context. This case was brought by 271 persons, but they were represented by 6 persons in the matter. So it was a representative action. It was not a case where all 271 persons filed affidavit and dealt with their circumstances in an individualized way. So I think that's important in terms of context. But Cara, I wanted to make a very important point in the context of what, in particular, Dr. Alexis was saying.
Okay, yes. So I understand that Dr. Alexis would be, uneasy about this part of the judgment. And to be frank, that's a part of the submission, legal submissions, both in writing and in oral, which I found to be particularly tricky in the sense that, well, let me explain what I mean by that. Okay, so pension rights, of course, are important because, for elderly people, this is what they depend on to survive. Pension rights are constitutionally protected. There's a section of the Constitution, I think it might be 88, in St. Vincent, and throughout the Caribbean regions, pension rights are protected, and those protections are not just within the the provisions that deal directly with pensions, but also within the fundamental rights sections that deal with deprivation of property. So I was uneasy about this argument because I am not saying, and we did not say by any means or in any how, that if you deprive the affected people of their payment and you send them on leave, then that would have been lawful or constitutional. What we said is that it would have been a less severe measure. And it's like a minute difference. But I pulled up our written submissions, and essentially what we did in paragraph 25, well, I think this is the final word draft that I'm looking at. But in paragraph 25, we said the following ways would achieve public health objectives with less or no interference with property rights of public officers. And we listed certain suggestions, and it goes from A to I, right? With A being the first alternative we said was exploring alternative modes of work for public officers, such as working online, which would require no interruption with employment. So essentially, the argument was that it's like a scale. So you go from the most draconian measure, where you not only kick them out of the workplace, you not only take away their salaries, but you take away their pension rights and their gratuity. That is why Justice Walburn said it was draconian. It was the toughest, like you were punishing these people. You were punished. It's a punishment. You were punishing these people for their insolence, for their refusal, their rudeness, refusal to take the vaccine when we told you to take it. So to me, it's a scale. So we were not saying that everything on this scale is constitutional, that everything is lawful. But what we argued, and we relied on the de Freitas test, where you have to show that there was a sufficient reason, that there's a rational connection, and importantly, it was the third limb that we were looking at, that this is the least restrictive measure. That there's no other measure, less severe measure that could have been taken. So it was focusing on that third limb that we just, we engage in this exercise as we looked at, A could have been done, B could have been done. We gave the court a list of other things that could have been done that would achieve the same effect, same purpose, keeping unvaccinated people out of the workplace, but would not have been as severe. So we didn't say that all of these alternatives would have been legal. We said that they would have been less severe. And as I said, it was an argument which it was very uncomfortable to make, but at the end of the day, I agree with it. It's a technical point, but I agree that if we are, with doing the de Freitas proportionality test, that's the exercise we have to go through. Are there less severe measures? Now, the majority, Ruggles said that the majority there, the way they handled this matter this issue was curious. I think that's a euphemism. I found it, I was very disappointed with how the majority handled this matter, because what I got from Justice Ventus's decision is that he said that there was no deprivation of property because the individuals, the respondents, did not qualify for pension. And it was based on the law, based on Regulation 31, that they did not qualify, and therefore they were not deprived. But ordinarily, Regulation 31 would not apply to them, because ordinarily, if you tell someone, don't come to work, you cannot turn around and say the person abandoned their job.
Yes.
So it is through the regulations that you change the law, you change, you change the situation, and you, in effect, prevented them from continuing their work, and you prevented them from getting pension and gratuity. And I really appreciated the fact that Justice Waldbank highlighted that, we provided evidence through affidavits saying that these public officers are saying that based on the regulations, we're not going to get pension. And we pointed to the various regulations, which dealt with pension rights. And it says, it says that if your employment is terminated in pursuant to certain regulations, then you get your pension rights. But Regulation 31 was not listed there. So we pointed all of that to the court. And the other side, the appellants, the government, they were silent on it. They never pointed to anything that would say, hey, these people get their pension rights. And can we, as humane individuals, people who come from a past of slavery, and I always refer to this because we're in a Caribbean context where horrible, horrible, inhumane things happen in the past, and we cannot forget that. People who come from that horrible, inhumane context, can we say today that it is right to simply tell someone who has worked for 10, 15, 20, 30 years in the public service that all of your work has gone in vain, and that because you didn't take the vaccine when these government ministers told you to take these injections, you have to become a beggar for the rest of your life? You're deprived of your gratuity, your pension. You maybe have to continue working. I don't know what work you can do when you're in your 60s and 70s, but this is it's a travesty. It's a human rights issue that we need to all be concerned about. I mean, I know I'm kind of preaching to the converted with this panel, but for all persons who are listening, you need to be concerned. You need to be worried. Human rights are important, not just, you should be concerned when other people are being harmed. Because tomorrow it might be you, tomorrow it might be your daughter, your granddaughter. So that's my 2 cents on the issue.
Yes, what you notice, Cara is saying she is not, was not in court suggesting that taking away the salaries on the World Bank formula would be constitutional. Take note of that. So what I would suggest to all concerned here, that statement made by Mr. Justice of Appeal Wallbank about taking away the salary, to me, is unfortunate because it indicates a level of, forget the word, desperation in putting the case. So what they need to do is to finesse the whole idea of proportionality. Take, for example, the proposal of working from home. That sounds very admirable, workable. That is the sort of thing you want to push. But the minute you start talking about should send them on leave without pay or with pay, without pay, that's inviting trouble. And the Dr. Vento's proposition that Regulation 31 is automatic, that's very unfortunate. There's nothing automatic about it. I gave you an example where here in Grenada, where we have fought that for years, and now routinely the PSC would write to the officer and say, we notice you haven't been coming to work. Come to work or come on such and such a day. That is humane. It doesn't disrupt public administration. It affords the officer an opportunity to say, I'm sorry, I was at work, whatever it is. But an opportunity is afforded. There's nothing automatic about that.
I just want to take some of the comments from the chat here. One person say, I think that sorry. My first question is, why was the vaccine mandate applicable to the working population only, or the rest of Vincentians go unpunished? I guess that person saw the vaccine as punishment. Jomo Thomas, who was one of the lawyers in the case, says that the employees at the parliament were compelled to take the vaccine, but not the legislators. Then someone is saying, did anyone take into consideration that they were given a chance to be tested every 2 weeks, but it was refused? Another person says, yes, Ms. Cara Shillingford, you said it best. Thank you so much for your arguments in this case thus far, and we look forward to more of the same at the next level. Another person, could the panelists expose the decision of the majority? Could the panelists expose the decision of the majority of the learned judges? Because all I'm hearing is contrary to the majority. Someone says the Privy Council has to give us justice. I guess that's an affected person. Someone says, yes, keep on holding on to the remnants of colonialism with these white men that don't know anything about the Caribbean, yet we say we are independent. Somebody says abandonment when you turn up every single day for duty and perform your duty until they give you a letter to say you are dismissed. Next one says, just listening. Chef Lord Valentine was one of the claimants in the case. Says, I'm listening. God bless you, Cara and Layne. Barbara Andrews, can the panelists address the case in relation to SGU and its workers? Sorry, we can't tonight. But I think the caution of Dr. Alexis is well taken on that point. Temporary leave is less intrusive and severe than permanent severance from my job. Although both are bad, but one is worse than the other. That's one of the claimants actually saying that. Then one person interestingly said, I received my letter December 17th and continued working until Easter the next year without pay. During that time, my school and many others had classes online. We could have been given that option. And then somebody says, leave without payment and the pensions would have been preserved. Dave then says, can the independent authority of the PSC be subject to the directives of the minister? Or is the PSC the only authority to make decisions with respect to pensions? And someone said, workers in Trinidad were offered leave without pay as an option. And Kenson says, I'm not getting it. It is interesting that the law had to be changed to facilitate the passage of the mandate, but this was not seen as unconstitutional. In fact, the legislation now stands fully against the constitutional rights of conscience and bodily autonomy. Somebody on the phone said this one is a long one, so I'll just read the relevant parts. This asks, what are the ramifications if these 271 people win the case? Can we expect the floodgates to open with other cases? That's essentially that.
Mm-hmm.
So those were the comments from those following. And I know that the program was really well attended, and I guess the views were really well expressed. And I just want to take a minute to recognize those who sponsored this program for us. Sponsored in different ways, not only monetary. In fact, in most cases, not monetary at all. Jail Professional Solutions, JMFM carried the program out of Canada, and Grenada Technical and Allied Workers Union, GTA.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Okay, someone is saying the second question was not answered, but I'm not seeing a second question from that person. So my first question is, my first question, and this is the second one. Why was the vaccine mandate applicable to the population, but the rest of the essentials were punished? Yes. So I want to really thank all our guests tonight and all those who following the program. And I don't know, Simeon, if you have any question before we conclude, because it was allotted that this was a very lively program. Simeon? You need to unmute co-host. Simeon, you need to unmute. Okay, Simeon doesn't seem to be hearing us. Okay, Ruggles, I'm going to ask you if you can make your answer. Yes, Simeon is coming. Simeon, you need to unmute. Yes, go ahead.
I've been serious.
We don't get to your claim. We don't get to your Simeon. Okay, Rox?
Yes. Okay. And just in the closing comments, I would try to cover it. One or two of the questions raised about the majority position. I think everything stemmed from the different views taken by the majority and the minority judgment. That one, there was no breach of the separation of powers doctrine. because the minister was authorized to do what she did. And we heard the exposition of Doc on that. But they disagreed with almost all aspects of the conclusion of the learned trial judge. And it's again stemmed from the premise that these workers were justifiably, in a sense, terminated in accordance with the existing regulations. So that was the conclusion. And as a result of that, they were saying, well, there was no evidence that they were that they qualified for or entitled to pension. And Cara touched on it a short while ago, but that was the essence of the whole case: the deprivation of property because we were not entitled. We have lost our pension rights. I think that was, when you strip everything apart, that was the key thing they were saying. And the majority was saying there's not sufficient evidence before us. In any event, if you're entitled to pension rights, you can still apply to get your pension. And I think that becomes like a chicken and egg situation. Which one comes first? Because if you are based on a disciplinary procedure, you are terminated, then your entitlement to pension will become an issue. So they are saying you are properly terminated, and therefore qualification for a pension does not arise. But even though you are qualified, you have not lost it. But the general point I wish to make in closing is that this is not an easy case. This is not an easy case for any tribunal at all. And it shows what it demonstrates, especially on the interpretation of constitutional issues. You can have brilliant minds differing, as you have here. And I made mention of Justice Henry, who is known to be very meticulous in her approach to issues generally, and in particular constitutional issues. She has been overturned, and I believe, as Doc alluded to, it's important that the highest court makes a determination on this matter, so that the law can be settled, because you will have instances, again, in the future where you may have emergencies arising of a different nature and of a health nature, health emergencies. And I think determining the matter at the highest level, and it may very well be determined 3-2, because when you go to the Privy Council, there are now 3 law lords sitting on the case. But at least it will bring finality to the whole issue. So I strongly believe this is a matter, and whichever side emerged as the winner, if you may term it that, at the Court of Appeal, is the kind of matter you want your final court to make a determination on. Not because of the matter itself and the particular fact scenario you have been presented with, but it's important for the development of the law, not just in St. Vincent, but in all the other countries, including Grenada, because all constitutions are more or less similar, if not identical in many respects. So I just want to end too by commending the program, you, the host, for hosting such an important program, for Cara in keeping the torch live and ensuring that when these constitutional matters, Cara and team, to face it and to deal with it. And so all in all, I think this was a very stimulating discussion. And with constitutional matters, the answers are never final or right in the sense. Whatever views expressed, and I want to say from my perspective, because I was not involved intimately with the case, it's sometimes difficult to comment authoritatively one way or another, because there are many missing links in terms of the information you get through the judgment. So thank you.
Yeah. Cara, before I ask you, Cara, I just want to read, it's a question, a comment from the co-host. I think he has some technical problems. The question is coming from him. I don't know if someone asked it or if it's his own view. How does the government COVID vaccine mandate violate the constitutional rights of public servants who opt not to receive it? What if someone in the public servant's household has symptoms of COVID, yet that unvaccinated public servant comes to work and knowingly or unknowingly passes on COVID-19 to others working in the same crucible? Him or her. Remember that COVID is a disease that can hit the entire crucible in a short space of time. In a short space of time. Is that ethical or legal if the vaccine can prevent it?
Okay, thank you for that question. So the question presumes that this individual this one public servant, right, who is on the list, because it's a list of public servants who the government had singled out for the vaccine mandate. It is not every public servant. So this question presumes that the public servant in question works in a place where he interacts with absolutely no one, other than his vaccinated employees. So what we have to consider is that the public servant interacts with members of the public. So if members of the public who are not subject to the mandates and who are unvaccinated, who might have a grandmother at home, who has COVID, and therefore that, the members of the public are exposed to COVID, and they are allowed to enter into the office, the public office, the public building, then they are exposing everyone to COVID as well. So it's a situation where, COVID-19 is a disease that it did not discriminate. It did not say, well, I'm only going to affect public servants. No, it affected everyone. So it is not logical, and it's not fair, and it's not ethical to single out one group of people to get a vaccine or to take a vaccine which is experimental. Whereas there are multiple other persons who could have gotten COVID and who could have affected other individuals. The other thing I wanted to highlight is that none of these mandates even considered natural immunity. So if it is that you're a public servant and you had COVID and it was like a little flu for you, it really did not affect you because you have a strong immune system and you have developed your natural immunity, you still have to go and take this vaccine, which is absolutely unnecessary in the circumstances. So, but that is the scientific aspect of it. Which to answer the question, I think it is unethical to single out certain public servants and tell them, that they must take the vaccine, whereas we are all members of the society in St. Vincent in the Caribbean, and we are all potential carriers.
Doc?
Section 39 of the Interpretation Act and Section 147 of the Public Health Act, in my respectful, humble submission, could not authorize the minister to issue this mandate. On the other hand, the idea that Rule 8.1 or Regulation 31 kicked in automatically is very unfortunate. There is practically, certainly in this situation, nothing to have stopped the commissions and the COP from giving a hearing to the workers before deciding whether the workers had breached these provisions. And the dissenting Justice of Appeal made that very clear. What has to be looked at carefully is the question of proportionality. And you would have heard, Ewart, that Cara is saying, quite frankly, that she herself has been spending time on this. More time has to be spent on that too. If the case goes further, because expect that the Privy Council will grill you on that. You have to have your answers ready. Not the kind of answer which, with respect, Mr. Justice of Appeal gave there when he added on this part about sending them on leave. Especially if they were going to be sent on leave again, mandatorily. All that is left now is for me to thank you, Ewart, for having me on your program, and again to pay high tribute to Cara Shillingford for raising these delicate and sensitive issues and doing so with quite impressive lawyering skills, and I say with admirable courage. It is not easy taking on the state. Look at what Mr. Justice Bank is saying, and the learned trial judge about the philosophy of constitutional adjudication. The question always arises, do general principles in public law decide cases? Well, quite clearly in this case, the general principles stated by Mr. Justice of Appeal, which Cara was reading just now, essentially he's saying whether you're in an emergency or not, the Constitution must prevail and human rights must be respected. And the trial judge was making the same point too. So we are proud in the Eastern Caribbean that this very important case was argued by one of our own in the Eastern Caribbean and responded to by one of our own, Anthony Astafan, and doing very great justice to it. And we look forward to the great work done by Cara Shillingford reaching the highest pinnacle at the Privy Council. And let's see what come of it. Thank you very much.
Thank you, Doc. I just want to, before we end, just endorse what you say. It's interesting that between Cara, if I may say, and you forgive me, between Cara, Ruggles, and yourself, we're talking about almost 3 generations. So I think there is a lot of hope for the future, despite sometimes we are a bit despondent. Yes, so you can see things being handed down, and I know the great work you have done over many decades, the work that Ruggles is doing, and now Cara is doing this work. They will disagree about things with the judgment, but that's the process. And as you say, we look forward to the Privy Council. And one additional point that is the gender balance also. It's also heartening to see not just a young person, but a young woman. And then, of course, Mr. Astafan is an experienced a male attorney. So we have that balance. I say that because I always receive, if I may say, some flack about the lack of gender balance on the program, and at least we had it in the court. So thank you so very much. I'm so grateful and thankful that you came onto the program, and we'll stay in touch. Good night, everyone. Thank you very much.
Right.
Right, good night.